Should I open an estate even if one of my sisters says she's going to contest the will? I'm going to answer this question for you in this video. Hi, I'm Probate Attorney Dan Scott, and I help families work through the probate process in a stress-free environment to allow them to have certainty and closure when they've lost a loved one. Now, here's the scenario. 5 children, no spouse. Father dies. And so now the 5 children are going to be heirs at law. But there's a will signed by the father that says 4 of my kids are going to be the beneficiaries of my bounty. The 5th one has already got everything that I want her to have from my estate. And so one of the daughters comes to me, not the 5th daughter, one of the first 4, comes to me and asks a question. So look, that last daughter number 5, has said, if you open that estate and try to probate that will, I'm going to contest the will. And so the question is, should you open the estate with the will that cuts out the 5th child, or just open the estate without a will? Well, here's the scenario. A will is generally presumed valid. If it's properly executed, then it's presumed valid. And that means that anybody opposing the will has the burden of establishing really one of 3 things. Either 1, that the will was executed under duress. Like, for example, I've seen cases where there was a caretaker, and the caretaker had an elderly person, and basically the proof was, look, the caretaker said, look, if you don't leave me something in your estate, then you're going to have a problem. You may not survive tomorrow. There were threats about that. I'm going to withhold your food. I'm going to turn the air conditioning up real high. I'm going to freeze you to death. All sorts of threats like that. That's often called duress. That is, there's pressure put on you to sign that will, and it's overcome your ability to make a decision. The second issue is, was there undue influence? Undue influence is basically where you've got somebody that's got such a close relationship with the testator that you come in and say, well, they overcame the will of the testator, the power of the testator to make her own decision about the estate. And the third thing is just fraud. She didn't sign the will, right? Or he didn't sign the will in this example. So those are the 3 things that really you're going to have to prove to overcome a will that appears to be properly executed. So yes, you should go ahead and open the probate. If the 5th child has got something, let them come on. Because otherwise you're going to have a division by 5, and unless you're willing to do that, then you're going to have to probate that will. And really, you're the one that's got the lever, because you've got a will that's signed, and somebody opposing the will has the burden, and it's a heavy one, to establish that that's not the last will and testament of your father. I hope you found this video helpful. If you did, would you subscribe to our channel and then mash the bell? And if you do that, then I'll be able to let you know when we publish new videos. And we do that pretty much all the time. Thanks for watching.